Hello, and welcome to this episode of BarChat. My name is Doug Brown. I'm the Executive Director of the Connecticut Bar Association. And here with me today is April Arrasate. She is the founder and COO of Curaleaf, one of Connecticut's 4 licensed medical marijuana producers. She is also the chair of the Connecticut Bar Association's Medical Marijuana Committee.
My name is April Arrasate. I am founder and chief operating officer of Curaleaf, one of the 4 licensed cannabis producers in the state of Connecticut. I am also the founder and chair of the Medical Marijuana Committee for the Connecticut Bar Association. I am extremely interested in the subject, obviously as a producer, but for many reasons. I wanted to just give you a brief overview of the program. And when it started, we have had the 4 producers were licensed in January of 2014. So, and at the same time, 6 dispensaries were licensed, or shortly thereafter. The dispensaries are run by licensed pharmacists. So the program has been in action for a little over a year now, which allows Connecticut patients who suffer from one of the qualifying conditions in this state to access medical marijuana as an alternative or in addition to standard pharmaceutical products for their ailments. Just to run through the process, if you are a Connecticut physician and you want to certify a patient for the use of medical marijuana, you can register online with the Department of Consumer Protection. There is a lot of information online to help you through the process. So the physician would register and be allowed to certify patients. Then a patient with a qualifying condition would come to a physician, and the physician would certify that patient did in fact have that ailment. And then the patient takes the certification, registers themselves on the Department of Consumer Protection website, and takes the certification to a licensed dispensary. As I said, the licensed dispensaries are pharmacists. So the pharmacist can actually guide the patient as to what form of medicine, what dosage of medicine, how often to take the medicine. And in that, it's a little different because typically a physician is prescribing exactly what to take and the pharmacist is really loading that prescription. But in this case, the pharmacist has a more active role as the cannabis expert. In some cases, a physician can surely weigh in, or if they wanted to have, and they had the knowledge, they could certainly prescribe a specific dosage. But in this case, in our state, so far, the pharmacists are charged with really the knowledge of cannabis use and cannabis efficacy for the qualifying conditions. And then the patient takes the product from that dispensary, and we are the producers, the 4 producers are supplying those products. And one of the common things that people don't know is the various forms of administration. So you're not just, there is an option to have pure flower, which is the smokable product that people are used to seeing, but you can also vaporize that pure flower, meaning it never catches fire, so you never intake the products of combustion. In addition, we have various oils, tinctures, topicals, there are edibles. There's so many ways for you to ingest. You can vaporize an oil much like an e-cigarette. So the possibilities are, they're there for any kind of administration, and we're really just getting started. So hopefully we'll be able to meet the needs of Connecticut patients.
Welcome, April.
Thank you. Thanks for having me.
I'm happy to have you here. This is a really interesting topic that a lot of our members really care about. It was January 2014 when Connecticut licensed its first medical marijuana producers and distributors. So we're about 14 months into the program. What are some of the highlights of Connecticut's medical marijuana program?
Yeah, so Connecticut's medical marijuana program is administered by the Department of Consumer Protection, which is nice and different from some of the other state programs because they really have a focus on medical regulation. So they're used to operating in that arena. Our program currently has about a little over 3,000 patients in it. And one of the great things about the program, it's extremely pharmaceutical, and it's really, they took the time to outline a lot of scenarios and really give us a lot of guidance as far as what we can expect and how we need to operate within the program. One thing about the program that is distinct is that they have reclassified cannabis as a Schedule II drug. So in the state of Connecticut, cannabis is considered a Schedule II drug. So what's nice about that is even though they have this very detailed framework that they've created with the regulations, if you have a scenario that arises that isn't within that framework, you can always refer to how would we treat this if it were just a Schedule II drug.
So they're using the existing regulatory scheme.
Correct. So you don't have to reinvent the wheel every time. You just turn to, a good example is driving under the influence. If you have, you have someone who's driving under the influence of cannabis, everybody is up in arms. How are we going to figure it out? But you're not reinventing the wheel. You just imagine, okay, what if they were driving under the influence of Oxycontin?
Sure.
You would handle
Another
it the same
Schedule
way.
II drug, right? Absolutely. How does the program itself protect Connecticut's residents?
So the department went out of their way to really protect people, not only people who are a part of the program, so the patients, the caregivers, people who are in the vicinity of a patient who's using, also physicians, but they also protect non-users. So if you are offending somebody else by using, you can't use in a public place, you can't use in a moving vehicle. They've really taken the time to look out for non-users. In addition, the protected class, the patients, the physicians, the caregivers, are also protected from discrimination as a tenant, as an employee, and as a there's another one they protect against: tenants, employees, and as a student. So you can't discriminate against somebody, not allow them into an institution, not allow them employment. Of course, you can't use on the job. Your employer can regulate that.
Right.
But they went out of their way to protect the parties.
So that creates some interesting issues for Connecticut employers that where they may smell and believe somebody's on marijuana, now that they may be protected if it's medical.
Yeah, exactly. I mean, that is actually one of the interesting problems that arises not only in employment but in criminal, like we talked about, driving under the influence, because marijuana is difficult to test for. It is stored in the THC is stored in the fatty tissue, so it stays in your system for 30 days. So unlike alcohol, where you can test the blood alcohol level and say, oh, you just were drinking, this is something where you could use last week, and then you go into work, you get tested, and you still test positive.
Sure.
So that's part of the reason that we really want to get ahead of the law here and make sure that we are anticipating some of the issues that are coming down the pike.
Right. With all the thought that's gone into this, what are some of the legal issues you might see coming at us for people involved in the program?
Right. So the number of disciplines that are involved are almost endless. I mean, it's really going to touch on everybody, which is part of the reason that I wanted to form the Medical Marijuana Committee, to get the minds involved, to get everybody ready for what's coming. If we use the other states that have legalized as forecasts for what's coming, you can see that all of the disciplines will be touched upon. Some of the ones that are, that off the top of my head are family law. Currently there's actually a case where it's being used in a custody battle. This is harmful to the children. No, I'm a patient. So that's an issue that it arises in. Criminal law, like we discussed, DUIs and the like, employment law, same. One of the intellectual property is an interesting one. I think you can't trademark. For example, I can't trademark Curaleaf on the federal level if they're going to say it's involved with marijuana because it's illegal.
Yeah.
So federal. Can you state trademark it? Can you federal? Is there patenting that we can do? I mean, it's fascinating. My favorite is constitutional law because it touches on so many things. So, free speech as far as advertising regarding the product, the Supremacy Clause, Commerce Clause, is the Controlled Substance Act even a legitimate, exercise of federal power? So all these things are kind of coming back, and it's really exciting. I'm anxious to get lawyers involved because it's hardly ever that you get something new.
I know, a brand new area of law.
Exactly.
Are there risks for lawyers who get involved with these issues?
So initially the bar was a little, the bar was a little concerned about how we handle this because it is still federally a controlled substance, a Schedule I controlled substance, meaning it has no medical benefit. So, but of late they have actually amended the rules of professional conduct, which specifically allows for lawyers to counsel clients regarding the medical marijuana program.
Oh, terrific.
Yeah.
That's useful for lawyers to know when clients come in and then the lawyers are wondering about their own ethical risks. What is the likelihood of the federal agencies would get involved in Connecticut's program?
Right. So even though the state protects all of these people, these classes of people and lawyers, we still know that if the federal government came in, the state can't jump in and protect them. However, federal involvement at this point is extremely unlikely. First, we have the Cole memo, which was issued a few years ago, which even though it's just a memo, it really discourages any intervention in state validated programs.
Okay.
In addition, currently there's an amendment defunding any intervention in state validated programs.
There's no money
so
for
even
it.
if the DOJ wanted to come in, they don't have any money to do it, and I doubt anybody's going to pull the money out of their pocket.
Not these days.
Exactly. And then, finally, even if the federal government were to come after states, Connecticut's program is so medicinal and so pharmaceutical that I think we'd be under the radar. I think they'd be more likely to go after a state that is legalized recreational or something along those lines.
Sure.
And really, currently there's some legislation pending, the CARES Act, which is Compassionate Access, Research Expansion, and Respect States Act, which would...
That's a mouthful.
That's a mouthful, but it would, well, it's federal legislation, so of course it's a mouthful. But it would reclassify cannabis on a federal level to Schedule II.
Okay.
Which would ease a lot of the burden, and it would, recognize state programs and all those, and really ease the burden on everybody.
So it seems like the federal government is kind of letting the states pave the way in this area.
Yeah,
so
I think
far.
they want to just not touch
Stand back a little bit.
Right.
Well, April, thanks so much for coming in and talking to us about this, and for all your work to help educate Connecticut's lawyers about the importance of this new development in the law. Thanks very much.
Thank you. I really hope people will join the committee. I'm anxious to bring on minds. No matter how you feel about the program, obviously I'm a producer, but no matter how you feel about the program, it's good to have all of these minds working together, and hopefully we can end up with consistent opinions in our state.
Absolutely. That's really what we want to be about here at the Connecticut Bar Association, bringing those diverse viewpoints together to make the law better and to make it Connecticut a better place for our residents.
I agree.
All right. Thanks, April.
A lot.